Welcome to the Smart Apartment Advisor Show. I'm JJ Panzer on a mission to help property owners get smart about property management. Today's show is the first in a series designed to help property owners get smart about landlord-tenant law, and I'm delighted to welcome my guest, Jeffery Woo. Jeff is an experienced real estate attorney with over 25 years experience, currently practicing with the firm Cooper White Cooper here in San Francisco. Jeff specializes in landlord-tenant litigation and real estate transactions. He's also a licensed real estate broker and was president of the San Francisco Association of Realtors in 2012. In his career, Jeff has represented many large institutional property owners and individuals in thousands of tenant buyouts, residential and commercial unlawful detainer actions, wrongful eviction, and uninhabitable condition actions. Jeff earned his BS in financial accounting from USC and his JD from UC Davis. While he wasn't able to make it as a Heisman Trophy winning quarterback, he certainly became a great member of our bar community here in San Francisco, and he's been involved in real estate since a very early age, starting out working in his family's real estate leasing business. Thank you for joining us on the show today, Jeff.
A great pleasure. Thank you.
So a couple of the topics that I thought would be really interesting to talk about today would be written leases, and certainly another hot topic today, illegal units and accessory dwelling units, talking a little bit about that.
Absolutely.
Let's start a little bit about talking about written leases.
Sure.
I get this call a lot. People call and say, well, my mom or dad has been operating the building for a long time, and as they declined in age, their files got lost, or I have no idea where the leases are for our tenants.
Right.
We have long-term tenants with no leases. Mm-hmm. Can I get my tenants to sign new leases? What can I do in this circumstance?
Sure. That's a very common question. We often see in our practice that there are no leases, or the leases are 50 years old and they're considered, they consist of one paragraph. They could be very small. In San Francisco, we cannot unilaterally force tenants to sign new leases. The law requires that if presented with a lease of essentially the same terms, that we can require them to sign it. And so because the law is written that way, there doesn't seem to be a really good reason to force a tenant to sign a new lease, which is exactly what they have. The only difference would be that it would have the new landlord's name, which doesn't create any more rights of that landlord. They don't need that to have the rights under the lease. Now, that being said, if a tenant voluntarily signs a new lease, if you present them with one, and maybe instead of what we might hope to send them a 30-page document which covers everything, we become a little more modest and say, well, we want to clarify a few things and make sure your rights are clear, that your lease doesn't say anything. Maybe we want to make sure that it includes parking because you've been parking there for 20 years, or storage because you've been using. You might be able to get a tenant to sign something like that, and that's possible, but that's mutual.
Right.
Even though we can't force tenants to sign new leases, there are ways that allow us to slightly modify the terms of the tenancy. As an example, some old leases or current leases even have attorney's fees clauses.
Right.
There's a question in my industry as to whether we want to have attorney's fees provision, which says that if there's a dispute between the parties, the winner gets attorney's fees.
Right.
Seems like something natural that you would want, but in San Francisco, one of the problems that we face as lawyers is that while our clients have money and spend money to pursue their rights, and a tenant may get a volunteer lawyer and pursue their rights, in the end, if a court rules in favor of the tenant, then that provision allows them to collect all the fees against my client. But if I win or my client wins, it's very likely that the tenant doesn't have any money to pay back the attorney's fees.
Right.
And so in a way, it becomes just a one-way thing as a practical matter. So in a lot of our cases, what we do is if there's an attorney's fees clause in a lease, we can serve a 30-day notice of change of terms of tenancy, removing provisions from the lease.
Okay.
And so often we do that,
Right.
Because it makes economic sense.
Right.
More modernly, what sometimes we do is instead of removing the attorney's fees clause, we limit the total amount of fees that can be collected to maybe 500 or 1,000, whatever the dollar amount, so that we can still use that attorney's fees clause as some leverage before there's a final court decision to resolve it. But if we can't and we go to trial and we lose, in a bad situation, at least we know that our liability is not tens of thousands of dollars in fees.
Right.
And it may be only 500,000, whatever we've agreed to.
Right.
So that's a very common provision. But San Francisco's law says that you cannot change any of the terms of tenancy and attempt to enforce it by eviction.
Right.
So that law came about because back in the day, landlords were, as an example, saying to their tenant, you no longer can have a dog.
Right.
Or you no longer can have roommates, and trying to create a situation where a tenant would suddenly become a default of their lease. And like a lot of what drives legislation in San Francisco, there's a very heartfelt story, there's a particular anecdote that we're looking at, a particular problem that some tenant's having, and then we that is used to morph into a law that maybe tries to solve that one person's problem, but then of course creates a host of other problems for landlords that have to deal with the new law.
Right.
As they try to implement it in their more typical circumstances.
Right. The majority of landlords who are honestly using those methods to manage their building in an effective way to deal with nuisance issues by changing house rules, things like that, are prevented from doing so because one person tried to take away rights, one by one to make a tenancy untenable for the tenants, so they have to move out as a way of a de facto eviction, where it's not actually that's not a good thing to do in the first place, and it shouldn't have been allowed, and it takes away the rights from the majority of tenants.
Exactly.
What about the situation where a landlord doesn't have a lease and they suspect that a tenant does? What happens in the circumstance where a tenant refuses to provide or produce a copy of that lease? Are you just stuck? I mean, are you...
Mostly, though there are some techniques that lawyers have tried and have sometimes been successful, but with almost everything, with landlord-tenant law in San Francisco, it requires, in order to protect your rights, an investment.
Right.
And so what some have done is they've implemented some sort of demand on a tenant and followed that up with a lawsuit.
Mm-hmm.
In order to create jurisdiction over that tenant and then allow what we call discovery,
right,
where they could force the tenant to hand over the lease.
Right.
And then at that point they would say, oh, okay, then I'll dismiss the lawsuit.
Right.
That's a pretty big investment. There's a risk of being sued for abuse of process, malicious prosecution, wrongful eviction.
Right.
Those are risks that have to be taken into account. And so, as a general rule, you wouldn't do it. There could be some circumstances where the existence or the lack of existence of a written lease could have a very important legal distinction in terms of the rights, and so I think in those circumstances someone would have to make a judgment about, do you go that far to do it? But other than that, there is no law that requires a tenant to give a copy to the owner of a lease. There is a law that goes the other way around.
Right.
Yes.
Right. The landlord has to give a copy to the tenant once a year on request.
Right. Exactly.
Right.
But the tenant does not have to likewise do that. So, just par for the course for what we have to deal with here.
In a circumstance where, let's say, a landlord has a good lease, it's only a few years old, and they misplace it, they can't find it, there are a lot of specific written terms of the lease that must be in writing to be enforceable, things like late fees, and NSF fees, and due date other than the last day of the month, things like that.
Right.
Does a tenant get to, if they suspect or find out that the landlord doesn't have a copy of the lease, do they get to revert to all of the original, you can't charge me a late fee because you don't have a lease and you can't prove it?
Well, if the tenant is correct that in the end you can't prove it, then you're gonna not prevail. But essentially, what the rule is, looking at it in a different way, written leases are very important and powerful because they remove dispute and ambiguity as to the terms of the tenancy.
Right.
You could have a oral lease, which says, if you could prove it, that you can't have roommates, or you can only have so many roommates, or you can't have a dog, or all of these normal provisions that you see in a written lease.
Right.
But you have to prove it.
Right.
And so it's possible that you could prove it through testimony, or you could say, this is an absurd example, but you could have a 8-track recording from 1969 where we talked and we said this is the terms of the deal and we said all agreed.
Right.
Of course, that's not very likely.
Nobody does that.
Nobody does that, or maybe there were witnesses, or maybe,
Right.
but absent that, that's why a written lease is so important.
Right.
Yeah.
Right. That's absolutely essential. Tell me a little bit about ways that you can make changes to habitability issues or nuisance issues in a building without making those sorts of unilateral things, noise issues. Or another good example is smoking. We have a smoking ordinance in San Francisco that says, you can't smoke, but if you have an old lease that is silent on the issue of whether smoking is allowed, you've got a whole conflict. So how do you, in a smoking situation, for example, make sure that one tenant who moved in and was told your unit is a non-smoking unit, but their next door neighbor smokes all day, how do you balance the rights of those two tenants?
Yeah, it's a really complex interplay. So if we take that hypothetical you did, and maybe we take it a step back, where we have the existing tenant who's smoking, and you want, as an owner, to have no smoking in your building, on future tenancies, you certainly can do that, but you clearly have a disclosure issue.
Right.
There's no, in my opinion, problem with saying to some tenants, new tenants, we don't have any smoking, and having existing smokers, because we don't have the power to stop them from doing that legally. So I think there's a disclosure issue that it's a non-smoking building, but this tenant is allowed to smoke because they were grandfathered in, essentially. Right. I think once the tenants have moved in and we're just managing the building, I think a landlord can say no smoking in the common areas.
Correct.
And so where there's secondhand smoke coming out, I mean, we've dealt with a lot of these problems. They're very dynamic. Tenants say, well, what am I supposed to do about it? And our position is something has to be done, because we're not telling you to smoke, and you can't have secondhand smoke coming out. You can open a window on the outside. Well, I don't like to smoke there.
Yeah.
Well, life has changed for all of us now, and that's the sort of part where the law and what really happens on the street, like what you do, is completely different. I mean, I can read off a book and tell you the laws, but the dynamic of working with that tenant who smokes and the complaints of the tenant who doesn't is one that the law is really only going to be useful in the end if we're all going to go to court and spend tens of thousands of dollars fighting a war where only one person might win and everyone's going to lose.
Everybody else loses.
The winner could still lose because they may have spent tens of thousands in attorney's fees just to solve this legal question that doesn't put a dime in their pocket, right? And so that's difficult. With smokers too, we have claims under the ADA, the Americans with Disabilities Act. I have I have basically a chemical habit, nicotine, right? And I can't stop smoking. And
I'm dependent.
You know?
I'm addicted. Exactly.
I mean, the ADA has just morphed into this, this bludgeon for landlords. So we had a tenant who fell stinking drunk, left the tap on because he was drunk, just completely flooded the apartment because they didn't find him for hours, and we began to evict him, and his defense was, well, I'm a drunk, and so under the Americans with Disability Act, I would like a reasonable accommodation of you leaving me alone. And,
that's the reasonable accommodation.
Yes.
I want another chance. I just want you to move on.
Yes, you should let me flood the place at least once.
At least once.
Yeah.
Next time you do this, then we're going to talk about whether I should be removed.
Exactly.
That's
so it's tough.
It's pretty tough, and interestingly enough, in my practice of dealing with that law a few years ago, it was interesting for us because we go through our leases and see how many old leases we had in a building that were silent on the issue, and then we contact those tenants and let them know, hey, this is silent on this issue, and we didn't have any conflict. There's a difference between the legal possibilities and the thoughts that everybody has and the legal anecdotes that people hear from attorneys versus the reality of situation on the ground, which I see every day. And in this circumstance, we reached out to people and they said, well, I don't smoke. I said, well, would you sign an agreement that you're not going to smoke and yours is going to be a non-smoking unit? Sure.
Right. It's great.
Done. And that's one of the benefits of living in such a liberal place as San Francisco, where people don't smoke that much. It really isn't that common.
That's right.
And we had one person who said, well, gee, I don't smoke, but I might have a house guest who smokes. And what do I do in that circumstance? Well, and then he went, I don't want them to smoke in my house. What am I talking about? Forget it. And he signed it anyway.
That's great.
And we were able, in a lot of circumstances, to turn buildings that had old leases that were silent into completely non-smoking buildings and eliminate the disclosure requirement, because going forward, all new tenants would have no smoking in their leases.
That's perfect.
And it works out well.
Well, it's a perfect example of how, as much as we all would like to avoid it, the human touch is still completely and utterly essential to the business of owning property. Because we're dealing with people, and I can't tell you how many times that we've had cases that are primarily driven by anger, by self-righteousness, by a feeling of the other side being unfair. And as much as we try to distill this down, at least on my client's side, to the financial aspects of it, can't always happen, and that's a shame. But the human touch is always what should be your first outreach to tenants, right? The bludgeon, the lawyer is the last one, hopefully.
Yeah, that once the attorney's letterhead or email comes out, all the gloves are off and the fight has begun.
That's right.
And it's really, you want to avoid that at all costs.
That's right.
Well, let's switch to another really interesting topic, in-law apartments. This, I think, has been something that I've talked about with clients, for a long time, but more in the last year than I think ever in my career. Mm-hmm. And so let's talk a little bit about the trade-offs. The city made it possible, as part of mitigating the housing crunch, to legalize in-law apartments in ways that were not possible before. So, for example, if you had an in-law apartment in your house and it didn't have an extra parking space, that used to be something where if you couldn't provide parking, they didn't want people parking on the street and clogging up the street.
Right.
So they wouldn't allow you to have a second unit, but they've relaxed that rule, and now you don't have to have parking.
Exactly.
Tell me a little bit about when you see it being a good idea for somebody to legalize an in-law apartment, and when you think it's a bad idea, and what they do in the case where it's a bad idea.
So to me, there are two circumstances where we see and talk, a lot about in-law units. So one is the one that you're kind of describing, which is just deciding whether, if you, for instance, had a vacant in-law unit, you want to legalize it, or under other legislation where you want to actually build one, and there's no tenant involved at this point. So at that point, the parameters, I think, of what most owners are looking at is income. Obviously, income could be fairly substantial. The practice of renting illegal units, while widespread still, has a fairly large risk to it, which you can avoid by renting legal units. The risk being that tenants can sue you for renting an illegal space. They can recover at best to you most or all the rent they paid for the last 3 or 4 years. But at worst to you, it could be substantially more damages for emotional distress, fraud, a lot of things. Could be big money. So if you legalize the unit or build a legal unit, then the benefit to you is that you don't face those kind of risks. What sometimes is missed is that once you build that unit and you turn your building into whatever it was into what it is plus one, so and the most common example, of course, is a single-family home, that you've now turned a single-family home into a 2-unit building, and the city does not allow you to reverse the clock later if you change your mind. So what does that mean for the owner? Well, one is that single-family home being rented is under a state law called Costa-Hawkins, which allows you to raise rent to market anytime. You would lose that right. The other issue is that, at least if you talk to real estate professionals, they don't build single-family homes very much in San Francisco anymore. And if you want to sell it, selling a single-family home with a legal in-law unit is probably worth less than selling a single-family home, and maybe incorporating that in-law space as part of the home. We sell property by square foot here, and the square footage of an in-law unit is worth a lot less than the square footage within a single-family home.
If you add that extra square footage to the overall square footage of that single unit, you get more per square foot overall than if you were to have a second unit, because the two have to be evaluated separately.
Yes, the appraisal process is different. The lending process is different, because the kind of loan you can get for a single family owner occupied loan it's going to be the lowest interest rate.
Right.
And really, if you think about it, not all, but a lot of buyers who are spending the San Francisco price tag of owning their first perhaps single family home may not be interested in having a tenant, right? And so you've sort of created a situation where it's not really what they want. You've changed the product into something that is not as sellable.
It's also not something that is as good as a real duplex. There are lots of buyers looking for a real duplex. They tend to be some overlap with single-family home buyers, but there's a significant number who are specifically looking for a real duplex with 2 floors, with equal apartments, more or less equivalent living amenities and things. And when it comes to someone who's looking to buy that kind of a property, they don't want 80% or 90% of the square footage is in one unit and 10 or 20% is in the other unit. They want 40-40 and 20% somewhere else, or 60-40, 50-50. They want a more equitable split so that they get a better rent for the other unit that they're not going to live in.
That's exactly right. And I mean, there's another part of that too. Duplexes, true duplexes, are attractive because they can be converted into condominiums. If you add as an example, into a single family home, if you add what we call an ADU, an in-law unit, legally, you cannot convert those two into separate units. So that option is gone. If you had a 2-unit building that already could be converted into condos under the current law, and you added an ADU, you may have you will have destroyed a kind of condo right, what we call fast track conversion.
The only condo right that's left.
That's left until 2024.
Well, assuming that in 2024 anything changes.
Correct. Yes.
But the current rule is that a duplex, a real honest to goodness legal duplex from today, if it's owner occupied by 2 different owners who live in the separate units as a TIC for 3 years continuously. Is that correct?
It's only 1 year.
It's only 1 year.
Yeah.
It's only 1 year. So then they can go straight to condo conversion and get an increase. Tell me a little bit about that increase in value that you see from going from TIC to condo and duplexes. Has it borne itself out as being a large, significant increase?
Yeah, substantially. I mean, I don't, while I'm a realtor, I'm not in the market buying and selling for other people. So there are better people to advise on that. But I mean, easily $100,000 per unit, as opposed to selling the whole building. I mean, you'd see a huge increase that's well worth the cost of conversion. But not only does it allow you to benefit from the increase, it gives you flexibility. If I own 2 condominiums in a 2-unit building, I have a lot more options. Maybe with my family, I can deed one to one kid and one to the other. I could keep one and sell the other, and then help fund down payments for my kids when they're adults. I can finance them separately. There's so many more options to do it. I mean, the basic rule that if anytime you can subdivide property, it's going to be worth more as a whole than as one applies to condominiums when you can convert.
Tell me a little bit about the kinds of upgrades that are necessary when you go from let's say you have a 2-unit building and you go to 3 with a legal 3rd unit. That's you're looking at it as always being a 3-unit property. What kinds of things become necessary in order to comply with the city's legalization process?
Well, first I'm going to just give you this caveat that this is certainly not my expertise, but my experience is that that it will not surprise anybody, that they require all the compliance with all the building codes that we all know. So there's going to have to be a certain ceiling height, plumbing and fixtures are all going to have to be licensed, installed by a licensed plumber with permits. Electrical, the heating requirements are the same. There's going to have to be 2 forms of ingress and egress, so you can't have something sort of trapped in the back of your building where there's only one way in or out. Some of the issues that it creates is that many of these buildings will have access to the yard only through one door in the basement, and so if that door is going to be used as a second egress, or just because of the design it's going to be covered up, then they're going to have to figure out now ways of getting people in the upper floors out for a second egress, like by building staircases, which is very involved. You mentioned before off-street parking; those things are usually waived. I think that this program of being able to legalize or build new in-law units or ADUs is really worth it for 3-unit or above.
Right. Right.
There's still an effect on condo rights, but the rules on condo conversion for 3 and 4-unit buildings are so tough now,
Right.
and so tenuous, because we're going to wait till, as you mentioned, 2024 to figure out even if the law is going to come back.
Right.
That the income, I think a lot of landlords have decided is justified if it's legal and they don't have the risk of renting illegal units.
So what about a situation where somebody's already committed the mortal sin of renting an illegal unit?
Yes.
What do you do in that circumstance? Your tenant's happy, everything's okay,
Right.
they don't know anything's up,
Yeah.
but you realize, you watch this
Sure.
this show and you go, oh my goodness, I've got a 2-unit
Yeah.
or an illegal in-law in my house,
Right.
and I've got a perfectly good tenant. What do I do now?
It's rough. Those people, those folks are providing tens of thousands of units of housing in San Francisco, probably underground in some ways, or at least hidden. And those people are, the way the laws are set up is that they're slowly being swept up.
Right.
So if someone reports that unit to the Department of Building Inspection,
Right.
they will issue a notice of violation, and they will say in the notice of violation, almost tongue-in-cheek, you either legalize it or demolish it.
Right.
But the second option is not available. That's the
Yeah.
parenthesis they don't tell you.
Ha ha ha,
Yeah.
demolish it. Yes,
Right.
exactly.
So when those come to me, and let's just, as an example, because it's the most common one, it's in a single-family home.
Right.
The only way that we can get the tenant out to comply with the rule is to LSAC the building.
Oh.
That is the only thing left. We used to have something called the demolition eviction,
Right.
but it required us to get a permit, and the permit is not obtainable anymore.
Right.
You can go through the effort of trying to get it, but in the end, nobody has ever gotten it after a certain point in our history where the mayor sent out an edict saying that he wanted to preserve all housing, even illegal housing.
Right.
And so planning just took it under their wing and decided that you need to get a change of use permit in order
Right.
for us to issue this demo permit, and we're going to deny it, and you're going to go through the Department of the Board of Appeals, and the Board of Appeals will not grant
Accept it. Right.
Yeah.
Exactly.
So that's what our experience has been.
Yeah, that's a rough situation. It used to be that you could get that permit to remove, say, the kitchen,
Right.
because the kitchen is typically the thing. You can add bathrooms and living
Correct.
rooms and stuff like that as long as it's done with code.
Right.
You can add that to your house and not get into trouble.
Correct.
But when you add a kitchen, a second kitchen, there's no logical reason to have a second kitchen in,
Right.
a single-family home.
Yeah.
So you could remove that kitchen, and then the housing would be uninhabitable by the tenant because it didn't have a kitchen, and then you could ask them to leave and pay them relocation expenses and things like that. And it was, at one point, it was okay,
It was okay.
and it's not okay anymore, and you can't go that route. So you have to
It
pay.
removes one of our 16 grounds for eviction, essentially,
Right.
and it just leaves us with
Right.
the LSAC. Now, there is a circumstance, like in your hypothetical, where the relationship is good,
Mm-hmm.
and the income is important, maybe, to the owner, obviously. So what we look at in there is risk analysis is how long has the tenant been there?
Right.
So if the tenant's been there for, let's say, 10 years, what we explain to our clients is the statute of limitations is 3, arguably 4 years.
Right.
That's as far back as the tenant can go to sue you for the rent they've paid.
Ah.
So in some ways, your case can't get any worse because they've lived there longer than the statute of limitations. It doesn't mean that they can't have a claim, but the claim can only go back 4 years. So
Right.
you could say the risk is relatively small, and I'm already down for the risk of 4 years.
The full maximum. Right.
Yes. So if they keep living there another 4 years, I will have collected 4 more years of rent, and
It's basically the same rent.
it's the same rent, and
Right.
I just do better, right? So sometimes people will just say, as we should do in every kind of legal question, they assess the risk and they say, I'm going to accept the risk given where I'm at. Now, if you're on day one of deciding whether to rent to an illegal tenant, that analysis is completely different because every dollar they're paying going forward up to 4 years is one that may come right back to them, and maybe that's not just a smart move.
Right.
But if they've already been there, then maybe that's
Now, the other perspective on that is that what you'll end up having to pay a tenant in a buyout is essentially going to be at least that rent back, plus also a calculation of the difference between fair market value of that unit and what they were paying for it, because they, if they've been there for 10 years,
Yeah.
the rent's arguably below market rent. And so if the place could be worth $3,000 on the open market and they're paying $1,000, and that $3,000 keeps going up over time, your liability in that circumstance could be increasing because you may find yourself looking to do a voluntary buyout and get the tenant to leave on their own before you go the Ellis Act route.
Right.
And that may end up causing the entire thing to cost more. So in that circumstance, with that sort of reverse perspective of what the cost is, it may be better to do the buyout as soon as possible as opposed to approaching it in the future.
That's very true, but I think what you highlight is the complex dynamics of what people have to decide. That's certainly a very important aspect, but there are others. So as an example, if we were looking at the situation and an owner was saying, well, I want to see if I can get them out, the first question we generally ask is, are we willing to get them out unilaterally, force them out? And the only way, as I described, is the Ellis Act. So if I did the Ellis Act, and then let's say in this hypothetical, the owner lives upstairs, maybe that's fine because they're not renting any other unit.
Right.
But if they're renting both the upstairs and the downstairs, I'd have to evict everybody out of there.
Right.
If I say, okay, well, I'm not in my ultimate, wisdom willing to Ellis Act the property, but I approach them, then the question is, what leverage do I have, right? And so if I talk to an illegal tenant unit, maybe they don't realize they have an uninhabitability claim that they can use as leverage with me. My only leverage is money with them, right? And if they say no, then all I can do is offer more or walk away. Right. So there are some very difficult complexities. There's also the issue of, if I Ellis Act the property because I'm willing to, I live upstairs, what am I going to do with the building, right? Because now I have an empty space. So maybe you have a kid who can live there. Maybe you're going to use it as storage. You're going to lose, let's just say, $1,500 a month. That's $18,000 a year.
Right. What's that worth to you?
What's that worth to you? Do you want to sell the property? Maybe it makes much more sense if you're really going to leave the property. You want to get rid of the tenant, because then you're talking to your agent about the difference in value between selling this property with and without a tenant in the in-law unit.
Right.
So the complexities are very tied to the subjective needs of the owner and what they want to do with the property.
Right.
And so you bring up a good point. It's just one of many others, depending on what they want to do with it.
Yeah. It's a complex problem, and certainly any individual owner who has questions about that, should contact their attorney, or they can talk to their real estate agent as well to talk about building value, or I can consult
or
them
property
as well,
manager,
or the property manager. So any one of those circumstances is good. So I think that's about it. It sounds like there's a lot for people to think about these days, and I appreciate your time and your effort to help us to illuminate those questions for people. Thank you very much for joining us, everybody, today. I'm JJ Panzer, the Smart Apartment Advisor, reminding you that even though life is short, it pays to take the long view. Take care, everybody. Bye-bye.